Hope everybody feels amazing after that Italian Supreme buffet. And you're all awake enough to listen to the next guest speaker, who I have the pleasure of introducing. Professor William Patton is charged with the task of reviving everyone from their food coma. He is
electroshock
up
therapy.
for the job. He's up for the job. Professor Patton graduated from UCLA Law School and went on to become a California State Public Defender, specializing in the representation of juveniles in the California Courts of Appeal and Supreme Court. While teaching, he went on after that to take his first teaching job at UCLA School of Law. He supervised students in representation of parties in child abuse litigation in the Los Angeles County Child Dependency Courts. In 1984, he started teaching at the Whittier Law School, where he served as the founding director of the Center for Children's Rights, the Associate Dean of Faculty, and the Associate Dean of Clinical Programs. For the past 8 years, Professor Patton has also taught forensic child and adolescent psychiatry and medical ethics at the UCLA David Geffen School of Medicine, Department of Psychiatry. In 2010 and 11, he was the chair of the Association of American Law Schools section on children and the law. And he has written more than 40 law review articles, book chapters, and books on children, including Legal Ethics in Child Custody and Dependency Proceedings, a guide for judges and lawyers. And he's also written the 3rd edition of Cases and Materials on juvenile law and its process. I present to you our next speaker, Professor Patton.
Thank you. Can you hear it? Yes. Answered the wrong question. It's resounding in every single city. Is this too loud? Okay. In every single city, in every county, in every state in the nation. You hear it like a Greek chorus. Our children are being hurt. Our children are hurting us. And it echoes back. Our children are being hurt, and you're not protecting them. Our children are hurting us, and you're not protecting us. And it goes to the system-wide level. Fingers are pointed. State legislators start thinking about how they can revise a system to both protect children and protect the public from children. And what kinds of debates do we hear all the time? Well, we know exactly what the systemic problems are. Poverty, unequal protection, insufficient jobs, insufficient medical care, insufficient medical and mental health resources that lead to both the dependency law and the delinquency law conclusions. But taxpayers unwilling to pay any money, therefore the legislatures have to be responsive to the public, and what do? They look for the quick fix. And when they look for the quick fix, they rarely engage in empirical analysis. What they look for in a quick fix is something which has a gut level ring. And one of the things, and what I'm going to point to today, most of what we've been talking about today, is large systemic changes. I'm going to talk about one little issue and how evidence-based analysis can affect the quality of hundreds of thousands of children's lives. And that's whether or not, both in child dependency and in child delinquency proceedings, we should admit the public and the press. Because what is an easy answer? The legislature says, hey, we're not hiding anything. We'll open the courts. We'll let you come in. You can take a look at it. The newspapers can come in. They can do white papers to determine what changes we should have. And therefore, what we'll have is more accountability. This basically indicates where we are in the United States in terms of jurisdictions. In 38 states, at least some of the proceedings in juvenile delinquency cases are open to the press and public. This doesn't mean every single proceeding. This could mean that maybe just at the detention hearing, or at the adjudication hearing, or the disposition hearing, they might be admitted. But at some phase, in 38 states, the proceedings are open to the press and public. And in 12 states, all of the proceedings are closed. In child dependency law, we see just about the obverse. We see that in 31 states, all of the proceedings in a juvenile dependency system are closed to the public and press, and in 19, they're presumptively admitted into the proceedings. Here are just some of the bills that have been brought in different states on opening the juvenile proceedings. Again, easy answer, quick fix. Let's just open the proceedings and we'll have more accountability. Accountability will necessarily result in better outcome measures for children and for families. You can see a couple of states, Connecticut and California, have been on there several times. I've been fortunate since 2000 to actually have been involved in every one of these, either testifying against or helping those who are opposed to opening the courts. If I have time, I'll talk about the last one, which is me versus the state of California. Hopefully we'll be able to get there. It's a pretty interesting case. The Court of Appeal opinion is supposed to issue on Monday, so I'm waiting. What I'd like to talk a little bit about is some of the empirical evidence that we need to think about when we're going to make a systemic change like opening the press and opening the system to the press and the public. This was sent to one of the judges, really poignant, from a little girl. My name is Catherine, age 10, live at a foster home in Suffolk County. I'm sending you this statement to let you know what my feelings are. I want people to know what happened to me because it's none of their business. It goes on and on, talking about, well, I don't want them in the court. I don't want to be on TV. I don't want to be anywhere. It's none of their business. So we know that in terms of abused children, that's where I'm starting the dependency side. In terms of abused children, most of these kids want this stuff to remain confidential. I did a survey among about 350 child and adolescent psychiatrists in California about what they thought about, from a mental health standpoint, opening the courts to the press and public. You can see 100% were opposed, 85% were adamantly opposed to opening these proceedings, because for many of these children, allowing the public to view the proceedings will substantially exacerbate their psychopathology. It will mean that not only is the legal system itself, as we see in a letter to the California legislature, it says the notion that publicizing this process will somehow benefit the child is hard to fathom. Publicity in the area of child maltreatment makes the child vulnerable to wide-ranging humiliation. It leads to repetition of the original trauma and basically makes treatment of these children more difficult. Here are some of, now if you're interested in this, I have like legions of law review articles that do this at length, but here are just some of the newspaper articles after the press was admitted into the proceedings. Some of the cases here. First one, the article included the parents' names. The victim was a 13-year-old who had been sodomized with a 4-foot-long cable. Think about this kid and all of the child's peers hearing about this case. Not just that, oh, this kid was abused, but all the specific details of the abuse, and it goes on. He was sodomized by the father, and then they talk about what happened when he would yell. Second case, a child victim tested positive for gonorrhea of the throat, also had nauseating photographs of the child with some dirty underwear, and finally, we have one where the article identified the child's school, the teacher's name, the fiance's name, and they talk about the very specific, brutal abuse that was perpetrated on the child. There are some wonderful studies that have looked at press coverage for almost a period of 100 years. This isn't something new. It's been going on for a long time. Press always says, we have ethical standards that say that we will not disclose the identity of a sexually abused child? Well, we know there are exceptions, that general rule exists. I looked 2 years ago, I wrote an article that looked at every single journalist ethics code in America, and then I looked at 30 other nations. There isn't one ethic code for a single journalistic organization that tells them they should not publish identifying information about a child who's been physically abused or emotionally abused, only sexual abuse. And what we found from the psychiatric literature is it's counterintuitive, but sometimes children who have been physically abused by trusted adults actually have longer-term and more persistent psychological problems than those in a single event of sexual abuse. But yet, there isn't a single ethical code in the United States that prohibits the publication of identifying information about children. This is the article I'm doing for the symposium here. And although it focuses mainly on dependency court, I'm going to transition into the theme of today, which is more what's happening with the juvenile court. So I'm going to take a look at how this empirical evidence that I've put together in this article applies to the juvenile delinquency context as well as dependency. Okay, don't you hate it when people put up slides you can't read? This was premeditated. I don't care if you can read it or not. It's irrelevant. You've seen lots of those this morning, right? What an idiot to put that up. Well, the first part of the sentence is probably correct, but I intentionally put up. I just wanted to kind of see, I've got lots of these charts. What I did is I looked through tens of thousands of pages of reports on the variables for child dependency law that each state must report to the United States. Now, some of the relevant ones, as you can see, you probably can't read it, but is there a right to counsel in child dependency cases? Did they meet national standards, systemic factors? Things like, once a child is placed into foster care, what is the percentage of abuse within foster care? Other really relevant questions, such as, once we terminate parental rights, how long does it take before that child reaches permanency in a new home living arrangement, whether that be adoption or long-term foster care? How long does it take? So these are salient, objective, data-based factors. And then what I did is I separated the 50 states into 3 categories. First category are presumptively open to the press and public. Second, presumptively closed, but the judge has discretion to open if the judge determines that it would not substantially harm the best interest of the child. Third, presumptively closed, they cannot be opened. Okay. The open court advocates had used qualitative analysis for years to argue that if we open the courts, everything will get better. Every outcome for children and for parents will be improved. But what my study shows is just the opposite. If we take a look at the 3 different sets of open court and closed court systems, and we compare them, what we see is, for example, and I'm just going to show you a couple. The article goes into dozens and dozens and dozens of comparisons, but here what we have is the mean number of national standards met. In other words, overall, how are the states doing according to the federal outcome measures? Well, we see the closed states had a score of 157. Okay, well, we're going to say, oh, okay, well, it looks like they're doing worse, so you should probably open your courts. Discretionarily open courts, 257, substantially better than presumptively open. Okay. Is my thesis that keeping the courts closed is better for outcome measures? No. My thesis is that the intuitive gut-level instinct that if we open the courts, it will result in more accountability, which will result in better outcome measures, is absolutely false. There is no correlation between whether or not a state has an open or closed system and whether or not the child outcome measures are better than in states that have a different kind of system. Why is that important? Because if we, in the child dependency system, where the U.S. Supreme Court has ruled there is no First Amendment right of the press to enter the courtroom, we're engaging in public policy analysis, we need to debunk that gut level intuition that if we just open the courts, everything will get better, and we need to debunk it with evidence-based information. Going forward, we have, you can see, to the next slide, this one is critical too, because in many instances, closed courts did substantially better than presumptively open courts or discretionally open courts. What's it telling us again? There's just no correlation between this change in a system of open versus closed and outcome measures. What also is interesting is there are 4 states that open court advocates for 15 years have been putting forward as the diadems that we should all follow. And those are Oregon, Minnesota, New York, and Washington. So I singled them out. Those are all presumptively open courts. And when you go into one of these legislatures and you debate, they always bring these up. Oh, well, they're open and they're doing great. Well, the reality is they're not. They're doing terribly. In fact, they're 4 of the lowest performing outcome measures in the United States. And in fact, when you accumulate the presumptively closed and the discretionarily open jurisdictions, 85% of them perform better on federal outcome measures than do the presumptively open courts. So again, this data is basically demonstrating that the easy fix is not a fix, and worse, by opening the courts, you're going to be increasing the psychological damage to the children who have already been victimized. Okay, now where do we transition? It's critically important at every phase. Here, like many jurisdictions, you'll have juvenile, no, here you don't, but in many jurisdictions that have juvenile courts that treat dependency law and delinquency law differently. We don't really put the 2 systems together. But what we know from reports is we have a substantial overlap in the children that are in the child welfare dependency courts are also the same children that we have in delinquency courts. Well, if in fact my information demonstrates that opening the courts to the press and public has systemic psychological problems for dependency children, why wouldn't that also apply to opening the courts in the juvenile delinquency side? Now, this is an old cartoon where you have to make some decisions, right? Are you going to put the money and educate people and not have them homeless, or are they going to get on the track and go to jail? And here we have a child basically treated like an adult with his number hanging from his neck. But again, this child is as likely to be in the dependency system as he is in the delinquency system. And we look at, traditionally, the purposes of the juvenile system. Rehabilitation, we know that. That's the essence of juvenile law. But at the same time, even in the California Supreme Court has said, you cannot have as a primary purpose punishment of a juvenile delinquent, although reasonable punishment can be used as one means of attaining rehabilitation. Okay? But deterrence. Now, why is this so important? Because a lot of current juvenile delinquency penology, and I'll call it penology as opposed to rehabilitation, deals with the concept of shaming. And we have lots of literature from different jurisdictions. I have another slide in a minute. But if you really look at this concept of shaming, even where it's effective, and it's effective in very limited circumstances, that's going to have a dramatic impact on children. I'm going to get to that in a minute. Another possibility is the 1980s through the early 2000s, we had a new interest creep into both the adult and juvenile systems. That's restorative justice. Hey, how about victims' rights? Victims aren't being taken care of here. What we need is 2 things. We need the child and the victim to get together so that the victim can have catharsis, and so the child can face up to what the child has caused, and that can lead to rehabilitation. And then we finally have a relatively new, from the 1990s, idea of therapeutic jurisprudence, where what we try and do is we design a system which is effective, but which reduces psychological trauma onto all the parties that enter the system. So, we've alluded to this, but this is probably one of the 5 most important Amicus Curiae briefs that's ever been filed in the Supreme Court. This is the Amicus Curiae brief in Roper versus Simmons. That was the case to decide whether or not it's an Eighth Amendment cruel and unusual punishment violation to execute juveniles. This is by every psychological and psychiatric organization in the United States. Why was it critically important? It wasn't just important because of the information. It was critically important because of the attachments. Because, think about it, in tort law, when you go before a jury and you can show someone you have a broken arm, they know how to deal with it. They know it's real. But if you go before, I can dance to that, but if you go before them and you talk about soft tissue injuries, no one believes it, right? Well, what was important here is we can show definitively by fMRI imaging what's really happening on the development of juvenile brains. This is something the court could really grasp onto. These are some of the things that we found from the case. Pruning and myelination, that's what's really going on in terms of the development of the brain. You have gray matter and white matter that's changing. You have pruning. Pruning is the equivalent of, the analogy I would give you is you have a smartphone with 1 meg of RAM, okay? That's the kid at 14. You put in 8 more megs of RAM, okay? That's the kid at 22. So that's what's happening. What happens is that computer can calculate tens of thousands of variables on cost-benefit analyses that it can't calculate when the child is less than 22 years old. Now, this is something that's relatively new. Polyvictimization. I put this here because in the literature, you'll see it hyphenated or you'll see it as one word. Okay, it's poly-victimization or polyvictimization. It's so new we haven't even standardized it. This is a new body of psychological literature that was developed in 2005 by Dr. David Finkelhor, and it's so important that actually for this conference, they did it for me. For this conference, the DOJ just put out bids for $1 million more of grants for studies on polyvictimization. But what it really is, it's an identification of a different level and kind of psychological abuse that a substantial portion of those in the dependency system and those in the delinquency system are suffering. It is identified on a yearly basis as multiple, sometimes 6 or 7 different sources of victimization. This is from, and I'll show a slide in a second, from schools, peers, physical, property damage, witnessing violence, and it persists. And one of the things that we found out that really distinguishes the victimized child from the polyvictimized child is to think about the victimized child as someone who had an event. Think about the polyvictimized child as someone who has a condition. Not only is this condition one which leads to serious psychological problems, but it's one which has great persistence, it continues throughout adulthood, and it's one from which these children have almost no resilience. They can't bounce back. This is a condition, a serious condition. Now, as you can see, what's going to be highly relevant is that this age group of 14 to 17 is the age group that is, in most jurisdictions, used as a variable for opening the proceedings. What do we say? Well, we don't want young kids who are in the delinquency system to have the press and public available, but we know if they're older kids, it's not going to affect them. The reality is, this new subset that's been identified is the group that's going to have the greatest psychological harm by admitting the press and public. What else do we know? Transfer hearings. What are the kids? Who are the kids? Down here. Who are transferred? All those kids. These are the national statistics on transferring kids. It's all the same kids. So if you're a public defender and you're trying to argue against your child being transferred and you have empirical evidence of polyvictimization, You should marshal that evidence and argue that this particular child, even though they meet these other qualifications, needs the rehabilitative service of the juvenile court. They shouldn't be transferred. You've got to treat them differently than someone who just had a property crime committed against them or who was abused one time in their life. These kids are radically different. Now, what else do we know about these kids? These are the different avenues that can lead to polyvictimization. The first one is dangerous families, disruptive families, dangerous neighborhoods, emotional problems. You'll see that there are commonalities, especially peer victimization, is a very common among children who have been polyvictimized. This just talks about the different levels of psychological problems that these children have. It's important to see these are the complex adaptations of the children who have been polyvictimized. Look at what's really important in terms of opening the courts. We have negative self-image. Okay? It's an incredibly high percentage of these kids have a negative self-image. So what do? We go back to the slide a little while ago. We want to shame them, right? You can shame them into being good people. Well, it doesn't work. It exacerbates the problem that led to juvenile delinquency. What else do we identify? Well, we have disassociation and social anxiety. These are kids that are withdrawn. So what's going to happen to them? Right? You put them up there on the stand and you let the whole world see who they are. You tell about all their horrible lives. And if you're in a really inhumane system that allows the press and public in not only at the adjudication or trial, but you let them in at the disposition where everything is disclosed, think about the incredible trauma that you're going to suffer these children to go through again. So what we find is that for polyvictimized children, they have very low self-esteem, they have guilt for what they're doing, most of them have post-traumatic stress disorder, and opening the courts is exactly the opposite of what a psychologist or psychiatrist would be recommending for these children. This is another article I've got, it actually is going to come out next month in the Journal of Hate Studies. We have to think about something else too. If we're going to open the courts, there's another subset, not just polyvictimized children, but LGBTQ kids. You know, what do they fear? I talk to these kids all the time. What do they fear by public hearings? To be outed. And when does the outing occur? At the disposition hearing. Why? Because we've got to determine what is the best placement for these kids. How do you talk about the best placement if you don't talk about their sexual orientation or identity? Right? And they are more fearful of this coming out in court. And you saw on the previous slide all of the different social mores that are playing on these kids as, now obviously some of the kids are out, they're proud of it. Could be a very different case, but for the kids that have not come out yet, it can be terribly debilitating. These are just some of the strengths and weaknesses of opening the system. We started late. I don't know how much time I've got. Do I have time to talk about maybe 5 minutes on another case? Who's doing? I do. Okay. Let me talk about the case of Patton, because for law students, you got to think. I want to show you how you think outside the box. Okay. So we had Judge Michael Nash. Do you know Judge Nash? Okay. Judge Michael Nash, a wonderful jurist. He has been the supervising judge of the Los Angeles Dependency Courts for about 15 years. He and I have debated on television. We debate all over the place. We sit on the same table and argue against one another in the state legislature. 3 times in California, the legislature brought open court bills. He testified for those bills 3 times. He got a little frustrated. So he decided to take things in his own hand. So he opened the courts himself. He issued a blanket order, an administrative order, opening the juvenile courts in Los Angeles presumptively to the press. Well, I didn't like that, and a lot of people didn't like it. So I filed a writ in the Court of Appeal, and they very quickly, in 3 days, said, "Get out of my life, you have no standing, who are you?" I said, okay. So then we had to find a client. We found a 15-year-old girl who had a just severe case of abuse under Judge Michael Nash's blanket order. The press came in, and then the child said, can I at least talk to the judge? I want to tell the judge why it's going to harm me by having the media here. And the judge said no. Under Judge Nash's blanket order, the LA Times has a right to be there when you tell the judge why you don't want him there. Talk about a catch-22. I mean, it's impossible. Okay, so we filed an appeal. The appeal's been pending now for a year, and again, it's scheduled to be released on Monday, so I'm waiting to see what the results are going to be. But in the meantime, I knew the appeal, unlike the writ, was going to take forever. So I had to think about something else. I said, okay, become the devil, right? If you can't be an angel, become a devil. You know, that's kind of what you got to do. So what did I do? I got a press credential. And I went into the dependency courts, and I listened to dozens of hearings. And based on those hearings, I wrote an investigative report. And then what do you do with it? What, you go to the LA Times? They won't publish it because they refuse to publish anything that's counter open courts. So what did I do with it? I filed it with the Federal Department of Health and Human Services, Children and Families Division, and asked for an investigation. The acting secretary wrote me back a nice letter saying, thank you very much for the report. I think there's sufficient evidence to transfer it to the San Francisco office. The San Francisco office then asked for a meeting with the California State Department of Child and Welfare Services. Now, why is this important? What did I use as a sword? Almost $1 billion of child abuse funding from the federal government to the state of California. Because why? They were violating CAPTA, and they were violating the Social Security Act by allowing non-parties to be present when Social Security information, HIPAA information, drug abuse information was all being released. So they reviewed it. They met with Judge Nash. Based on that meeting, Judge Nash modified the order and reinstalled all of the federal rights. Now what I'm waiting for, and I'll find out on Monday, is whether or not we were able to declare his entire blanket order, presumptively opening the courts to the media, illegal. Thank you.